Okay.
There you go.
Okay. Are you going to be using the same PowerPoint presentation you used from the AFL-CIO?
We were.
Oh, I did not.
Right,
Yeah,
we
we
thought
weren't.
it was a. Go ahead, Jacqueline. I'm sorry.
Yeah, I'm sorry. I didn't know that you wanted an actual presentation. I thought there was more question and answer, but I can work to get that to you right now, Andrea.
No, we printed it out just so people could follow along with it. So
Yeah, I have one. We can use the one we used last night and just leave out the last few slides and walk through. Yeah, we
Okay.
can do that. Would you prefer that you have a brief presentation on what it is? Would that be helpful?
okay. Also, is there any problem with you using this recording later to convince the company they're wrong?
So let's just think it would be helpful to you can use the recording, but I think we want to make sure that we're clear about what we're doing here, which is telling you what the statute says and doesn't say. For example, the statute says an employee can receive both employer provided benefits and CTPL benefits. It does not say an employer is required to provide both employer provided benefits while the employee is getting CTPL benefits. So as we go through this, I just want to make sure that when we talk about what's permissible, that doesn't mean that it's required, because I think that may be one of the issues that you're having. And then the other thing that may be going on is if the employer decides to make changes, under what circumstances can it make changes? Those are NLRA issues. Those are not CTPL issues.
Okay.
So, but you know,
so
if
you've
you just
already
want factual information about the statutes, absolutely, that's fine.
So you've basically already answered the question. You guys have answered it in writing once. You've answered it on a Zoom meeting another time. But I want to ask it again, if you don't mind. And we have a negotiated short-term disability benefit, which pays a certain amount depending on how much money you make. And then Connecticut paid leave comes in. The company's position is, or the position they have taken is, they no longer have to pay our negotiated benefit. And since Connecticut paid leave would be primary and it would be paying more, it basically zeroes out our short-term disability benefit.
So we can specifically answer you that the CT paid leave benefit is not required to be primary. There's nothing in our statute that says it is primary. Our oft stated and written answer is the employer has to tell us if their benefits are primary or secondary, and then we'll account for it accordingly. So
Yeah, because basically, if Connecticut paid leave is primary, you pay whatever the benefit is, and the companies would pay the difference between that and 100% of a person's normal wages.
has the option to.
Right, they
It's
can.
not required to, but is
Yeah,
there's nothing that prohibits
they
them
have the
from-
option to, they can, but under our circumstances where it's a negotiated benefit, we say it's required. And so if the company was the primary payer, they would pay the full amount, and then Connecticut paid leave would pay the difference between the short-term disability and the 100% of their normal wages.
Yes, with a slight caveat. If there's two ways that this could happen. One is the employer pays 100% for, say, 2 weeks. And then we would start paying at the beginning of week 3, right? So that's one option we see a lot of. The other is the employer pays something less than 100% and they're primary. And we say, okay, what percentage are you paying? You're paying 60%? Okay, well, we will pay 40% of what we would normally pay. The reason we can't guarantee that we're going to pay the exact difference between what the short-term disability policy pays and the regular wages is because our benefit isn't based on what a person earns today. It's based on the 1/26 of their highest 2 earning quarters from the first 4 of the last 5 most recently completed quarters. So it could be from a different employer entirely. So we can't guarantee that, if the person's earning $100 and the short-term disability benefit is $60, we can't say, oh, we're going to make sure we give you 40. We're going to pay you 40% of what we would normally have paid because of that difference between how we calculate benefits and how employers calculate benefits. So it sounds a little bizarre, I know, but there's sort of no other way of kind of squaring that round hole.
All right, I understand, but the short answer is yes, with a few,
Caveats, yeah.
with a mathematical equation that nobody's going to figure out sitting here
Yeah, basically,
without having an individual's work history.
right.
Okay, all right. That's all I needed to know, and I may have to step out. So you guys, I thought that you were going to go through like the same presentation that you had.
I have it up if you want to do that. I'm
Okay.
happy to do that.
All right, so our tech person is going to take over from here, and I guess,
All right.
how do you want to handle the questions?
I think we can just go ahead and have people step up and ask their questions.
Doing what?
They can just step up where you're sitting and
Okay.
just ask their questions. That'll be
All right.
easy enough.
That's fine. All right, thank you.
All right, you're welcome. All right, good morning, gentlemen. I am Andrea Barton-Reeves. I'm the head of the Paid Leave Authority, and with me is Erin Choquette, who is our general counsel, and Jacqueline Cozen, who is our legislative liaison and senior advisor to the agency. I'm going to share my screen to our first slide and just do a really brief presentation for you regarding what paid leave is. Can everybody see my screen?
Yeah.
All right, great. Thank you. All right, I'm going to turn myself off because I do a lot of gesticulation that can be.
Andrea, I think you turned off your volume instead of your video. There.
Yeah, I just, all right, now they're both back on. All right, here we go. There we go. I think we got it now. All right, so what is paid leave? I think we all know what it is. It is a source of income replacement for those employees who are taking family and medical leave, military leave, and in our state, family violence leave, and it offers income or wage replacement for those eligible employees that can't work for the same reasons that are covered by the Family and Medical Leave Act. What it does not provide is job protected leave. That is provided by the Family and Medical Leave Act itself. That attaches after 3 months of employment with an employer, and that law changed in January of this year. It is in fact employee funded through a payroll deduction of 0.5%. It does in most cases provide up to 12 weeks of income replacement. If a woman is incapacitated during her pregnancy, that leave can be as long as 14 weeks, depending on the information that's received from her healthcare provider. It does apply to most businesses. There are some exceptions. I'll run through those in a little bit. Those who are self-employed or sole proprietors have a residency requirement, but if they meet that requirement, they may opt in if they choose to do so, but if they do so, they have to remain in for 3 years. As we were discussing earlier, the weekly benefit is really dependent on the employee's income, and that's a formula that's in the statute, but it is always capped at 60 times whatever the prevailing minimum wage is, and right now, that's $13 an hour, so that would be $780 a week. The eligibility criteria for the paid leave benefit is an employee has to have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 past completed quarters, and that can be earned from 1 or more employers. They also have to be currently employed and working in the state. Or if they were employed, there's a 12-week window after that employment ends where that person can then continue to apply for the leave if they meet the criteria, the other criteria, meaning there's a reason for the leave that's covered and they have their earning capacity and they worked for a Connecticut employer. As I mentioned before, the sole proprietor or the self-employed individual has a residency requirement. They opt into the program, they pay into the program, and then they can participate, and they have to stay in for 3 years. Those entities that are not participating are a few. There are state, federal, or municipal employees who have not bargained to participate. They're known as covered public employees, and I'll go over the definition of that in a moment. The same is true for local or regional boards of education, with the exception of those who are also covered employees. Those are essentially those who are in a collective bargaining unit who have bargained to participate in the paid leave program. Non-public elementary and secondary schools, that's usually our independent schools, parochial schools, have never been covered by the Family and Medical Leave Act in this state, so they are also not covered by the paid leave law. There are some other interstate employees and employees of sovereign nations, like the 2 tribes that run our major casinos in the state. They are considered sovereign nations. As we all know, they are not covered by the paid leave law, and they have their own version of their Family and Medical Leave Act. And you can see it also includes spouses of active military members who are continuing to pay taxes in the state where they are, railroad workers, truckers, as I mentioned before, interstate commerce workers, essentially. Now, just to circle back a little bit on what is a covered public employee, they are, for the most part, the managerial non-unionized employees of the state of Connecticut as one category. The second are the unionized employees of the state who may choose to collectively bargain to be included in the program. The third are employees of municipalities. So that's towns, cities, boroughs. There's a very extensive definition of municipality, which you can see at the bottom of the slide. And if the bargaining unit in that municipality, it chooses to participate in the paid leave program and votes to do so through collective bargaining, then everyone who works there, whether they're in the union or not, is now a part of the paid leave program. And the same is true if that decision is made by a bargaining unit in a local or regional board of education. The question we often get is what if there are multiple bargaining units, as there often are in workplaces, so that the bargaining unit that agreed to participate through collective bargaining binds those who are not in the bargaining unit, but it does not bind other bargaining units. They have to make their own decision as to whether or not they're going to be included. Okay. So then let's talk a bit about the qualifying reasons for leave. There are essentially 6 of them. First is medical leave, also known as an employee's own serious health condition. And that can also include serving as an organ or a bone marrow donor. And it also includes pregnancy. Bonding leave is available for parents, period, regardless of gender. And it can be taken for up to 12 months after the time that a child joins your family through birth, adoption, or foster care. Caregiver leave is available to workers to care for someone who is out because of a serious health condition. So for example, you may have someone who may have been the recipient of an organ through an organ donation, and that person requires care. A person can take the leave to be the organ donor recipient, and then another person can take the leave in order to care for them. The next are the 2 types of military leave that are covered. They are military caregiver leave, that allows a worker to take time to care for a covered family member who is in the military and has experienced a serious illness. And that can be a behavioral health illness or physical illness or both that they suffered that occurred, I should say, in the line of duty during active duty. The qualifying exigency leave is for those that are called up to active duty. And that can be a spouse, a child, or a parent who's been called up. In both of these, a person can take up to 26 weeks of leave, that is permissible, but only 12 of those weeks will be paid through the paid leave program. Finally, we have what's known as the Family Violence Leave Act. This act has been active in our state for a number of years, and it already allows up to 12 days of leave in a calendar year to attend to those issues that arise from family violence. But they have never been paid unless a person accrued enough time to cover them. And now a person can, in fact, apply for that leave and also apply to the paid leave authority to have benefits that can cover it. Let me talk a little bit about paid leave and COVID-19. We get a lot of questions about this, and almost 30% of the claims that we've received have been for COVID. COVID is, in fact, it is a very serious condition. No one is arguing that, but our statute has a specific definition of what a serious health condition is that is covered when you apply for a benefit. And that is, it either requires an overnight stay or it incapacitates the employee or their family member for more than 3 consecutive days, and they have to receive ongoing medical treatment, or it results in the exacerbation or the worsening of a chronic condition that causes that employee to become incapacitated, and it requires care from a healthcare provider at least twice a year. So while COVID can be very serious and make you very ill, and I know because I've had it, if it doesn't meet these 3 criteria, at least one of them, then it is not covered by the paid leave law. The other thing that's important to know here is that there is an expanded definition of family under the Act, and that definition is known as related by affinity. So that means that the person if the person has a specific or significant bond with someone who's in their family, but not necessarily through marriage or blood, they, with the appropriate documentation, can show that they need to take time off to take care of that person. So it might be a godparent or someone who's always been a close family friend that is considered an aunt that the people may have grown up with that might need care now that they're older. That would be one of the reasons that we might consider someone to be related by affinity, and then they would have an opportunity to take leave. We often see this with couples who have been living together for significant periods of time, but have chosen not to marry. I don't know why this slide is doing this, so let's see why it's acting up like that. Okay, so how do you apply? You apply for paid leave in 2 ways. One is calling the toll-free number that you see here on the screen, and the other is by going through our portal, which is ctpaidleave.org. We have partnered with AFLAC to be our claims administrator. The employer's role is to verify employment details that include some of the ones that Erin spoke of, which is what is your schedule? How long do you plan on being out? Do you offer any kind of benefit and what it might be? Do you get paid for holidays? All of those things we ask so that we can determine how and whether we should modify the benefit payment that we will make. Benefit payments are made weekly, 1 week in arrears. They're paid on either a debit card or direct deposit. We do not issue checks. If you go onto our website, this is immediately what you'll see. And so the claims process is right up front. And then the last thing I'll mention is that, and actually my slide is missing here, is that we have a number of small businesses, which I know might not necessarily affect you, but those small businesses require a lot of support. And there is a page here, so we can get small businesses if they need to get to them. And that there's not a specific definition of a small business, but if you do have businesses that are new to family medical leave and paid leave, this is an excellent place to direct them so that they can understand how the process works better. And so I'll stop here now. That is essentially family and medical leave in a nutshell. Any questions?
Anybody? Oh, where's Chicken Man?
Morning.
Good morning.
Thank you for doing this.
You're welcome.
It's been a little bit hectic for us trying to understand all this. But I appreciate you doing that. I was the one that asked for this. So Pete did a good job of getting our main issue out to you and getting an answer. So I'm not going to bother with that. I did send you some of the other questions, and I'm sure there's more. In fact, I got a couple more I want to add to it. So and I think you might have already referred to this. One of the issues is when we do have a dispute with our employer over this, and we understand it one way, they understand it another. There's really no one that can go to say it who's right. The adjudication process, other than appealing a claim that gets denied, I think you're saying we have to go to the Department of Labor, correct? Is that who does it?
Yeah, so for a claim that is that your worker believes is wrongfully denied, that is the Department of Labor. Right now, we are hoping to get a statutory change that will strengthen and make more clear that they also have the right to hear claims when paid leave benefits are wrongfully denied by an employer. So an employer, by either through an act or deed or policy, appears to be blocking a worker's right to get access to the paid leave benefit. right now, it's not that clear in the statute that the Department of Labor has specific jurisdiction over that. So that's what we're trying to get cleared in this legislative session.
You're actually working on that now as
We're
a-
working on that now. We are.
good. Yeah, because, if we're gonna be talking to the Department of Labor over every denial, we're gonna be busy. And
Yeah.
there's gonna be requirements they're gonna have to allow us to represent people because most of our members aren't knowledgeable about how it works, especially when it comes to appeals and stuff. And we end up doing it for them. And then we run into the problem, well, we can't talk to you because it's a HIPAA problem or something like that. So we got to get that needs to be straightened out. Okay, so
Erin, did you want to add something?
Yeah, I was just going, okay, I'm off mute. I was just going to show you the DOL website. I think I can share my screen. So they have an online, actually, Andrea, if you, or Jacqueline, if you let me share. They have an online portal now. So it covers if someone applies to CTP leave for income replacement benefits and we deny, so that person can appeal our denial decision saying, you weren't eligible for our benefits or some qualifying condition. They can appeal the denial of our decision to DOL. And then right now, if an employee has asked for FMLA leave, say they want to take FMLA leave to care for a family member by affinity, they want to take leave to care for their grandparent or whatever, and the employer denies that FMLA, the employee can go to the DOL website and file their appeal. And so they've got all their information here about FMLA changes and forms. So I think it's really useful. But then if you scroll down, they've got the complaint process. I think you want to double check with DOL. They do say attorney or representative. So I don't know if they're already prepared for you guys to help your members. They have a lot of information on this website, which I'll throw into the chat.
all right.
How to file those appeals and how you access it. And as I said, I know that they reference representatives being able to help with those. I just want you to be aware that, if you've got a member who's trying to get their job protected leave and the employer is saying no, then you should go straight to DOL. If you've got a member who's denied benefits from us, they can either request reconsideration, we'll work on it, or they can go to DOL and we'll deal with it there.
All right, I appreciate that. I really didn't know that was there. That's good to know. Unfortunately, though, that's just for denials and not for like the issue that we have with our employer right now.
The statutory interpretation issue, I think, is really,
Yeah.
and
And
I
that
think you're
being
really
said-
going to be at the NLRB, honestly. I think that's
So-
where that is.
And I wanted to make my point on that. I think Pete did a good job with you guys before. But as you know, by allowing the employer to determine if you're going to be primary or secondary payer, what Electric Boat did was they said, we're going to let Connecticut pay for our benefit with the tax money that comes out of our paychecks. I would think that's illegal. And I think that's something that should be brought up in the legislative session. These bosses are using Connecticut pay leave to pay for a benefit that they negotiated with us. And I wanted to make that point. And I think you guys know that anyways. That's not your fault. That's the way they wrote the law. Okay, a couple things. I had mentioned in my letter to you guys that the application process was, well, I'll just say it was not user friendly. You got 16 pages, a guy gets 16 pages in his package to fill out to apply with you guys. It has everything from W-4 forms, medical evaluations, doctor's notes, pictures of your license. A lot of my members aren't computer savvy and it's difficult for them to receive that. A lot of my members that are asking for this are very sick. And the last thing in the world they need is to go through a process like this. I have a member that lost, because of the way it works, our short-term disability stopped payment to him, said you got to go to Connecticut paid leave. He had applied for Connecticut paid leave back in December. He went back to work before he got paid. In fact, yesterday, he finally received a check, which was fair. So on the, as far as the check goes, you guys did good. But he was out of work for almost 2.5 months. And it took that long to get through the paperwork process. So I really like to identify that we need to streamline that. It's difficult for people. I don't understand. Sometimes you talk to one of your reps and they'll say one thing to one person and then another person will call me up and say, well, that isn't what they told me. I'll give you an example. My own case. I had COVID in January, right? I was quarantined. I tested positive, I was quarantined. I was told by my short-term disability people to get a hold of you guys first, right? I called your rep, excellent. I'm not going to name her name. She was very friendly and very informative. The only thing is, she says, I'm not sending you the forms. She says, we're going to deny you anyway. So just tell your people, just tell you guys that we're denying you. Now, this was early in January. I know it's changed a little bit, but I said, no, I need a written denial. So she sent me an email with the wording that Connecticut paid leave don't pay unless you're in the hospital. Basically, they didn't, my benefits people denied it, said that's not good enough, right? So I still haven't collected, right? I've been back to work. Another person was told that, you can't go back to work until you have a positive test, which is not true. I mean, a negative test. So, everything is, there's some inconsistency with your Aflac people. Most of them, from my understanding, have been nice and helpful, but that it's not working out completely.
Yeah.
I'm sure our people haven't been friendly either.
No, no. There's no need. So in the spirit of full transparency, we recognize that. So they're in the process of being retrained. We have, was it 6 or 8 series of retrainings that are happening in this month? Because we recognize ourselves. We will call almost like as secret claimants to see the kinds of answers that we get as well. So we recognize that, and we're in the process of fixing that. So I apologize that you had that experience, but we're doing something about it.
Okay, thank you. Can you explain what the employer verification form is all about? It's complicated because I've had people tell me that your representatives said we can fill it out ourselves. And I've been told, no, you got to go to our employer. They got to send it to you. So I'm not sure exactly what the right process is.
Yeah. So I think maybe the confusion is the employee could upload the completed employment verification form if they get it back from the employer, or the employer can send it on directly. But the employer needs to complete it. And actually, as Andrea mentioned, we've been hearing feedback and trying to make changes as quickly as possible. And one of them was on the kind of complicated nature of the form. So we're revising it. The new form will be out hopefully by the end of next week, actually. There are some information we need to make sure that we're doing the program in accordance with the statute that we can only get from the employer. Like, is the employee receiving workers' compensation benefits? There's no central database for that information. The information about the paid time off, we need verification from the employer about what paid time off it is paying and if it's primary or secondary. We also ask for information about the employee's schedule, which goes into making sure that their employee's entitlement is equated to their schedule. So for example, if you work overtime, you may be averaging 52 hours a week. So your entitlement is going to be based on those 52 hours, not just a regular 40-hour week. So we just need verification about what that schedule is, so we can make sure that people are getting the right entitlement. So those are the three big areas. The fourth doesn't relate to you guys as much, but we're also specifically asking the employer to let us know if they're one of those non-covered employers. So that,
Yeah.
employee of the federal government isn't applying to us for benefits, and the employer just fills out the form because they're like, oh, well, nothing tells me I'm not supposed to fill it out. So the employer fills out, the employee gets the form and gives it to the employer. The employer fills it out and can either give it back to the employee for the employee to upload, or uploads it itself, or emails or faxes it to Aflac itself. So, and then that becomes sort of 1/3 of the documents that are needed, along with the identity verification to make sure that the employee is a real person and is really the person who's applying for benefits, and that there's not some identity fraud going on.
Oh, yeah.
And
I get
the leave documentation, like the med cert or the adoption papers. So those are the three kind of buckets that the employee needs to make sure gets sent to Aflac, either by doing it themselves or having the doctor and the employer send in their own stuff. And I did want to mention, because you had mentioned about folks being sick, and it's really difficult to manage this when they're sick. Friends and family can help. There's nothing that says someone can't help the sick person apply for benefits, but to protect that sick person's privacy, we say, we're not going to share information back with someone who's not the employee unless the employee fills out that authorization form, and that's to protect the employee. So I just wanted to make sure we reference that, because I don't want people to feel like they have to get out of the hospital bed and find a fax machine. You can absolutely delegate that task off to somebody else.
I think, and that makes sense, but I'm gonna tell you, the reality isn't there. Because there's a lot of people that are by themselves. That's the ones I hear from anyways.
You making lots of furious notes, because you really make a really good point. We're trying to figure out how to balance this concern about fraud too, which is why we ask for so much stuff, because we do get a lot of feedback that, Washington State and a couple of other states were really struggling with fraud, and we know what happened with DOL, but there might be a better balance that we can strike. So that's why the feedback that you're giving us is really important. So I would just want to thank you for that. We're going to take it back and figure out what to do.
I'm just gonna give one more feedback. Don't believe everything your electric boat says to you too, because they're known for their fraud. All right. I'm gonna ask one more question. I don't want to use up all the time. So one of the things I'm not clear on, and I've been looking into this for a while, is can you just explain how someone files for intermittent family leave? Because that's a little complicated, I think. And I heard that you do that and that you do it well. So I'd like everybody else to know how it goes to do that.
And would you mind answering? She does this much better than I do. So yeah.
Sure. So intermittent leave is you have a condition, or you're caring for somebody who has or the qualifying exigency where you have to go do something, but you've got one leave reason, but you're out for probably relatively short blocks of time, all associated with that leave reason. So I have migraines. They come sporadically, but when I have one, I have to go lie down in a darkened room. I can't work. So I would notify my employer that on the FMLA side first, notify my employer, I have migraines, I need leave for this. Here's my medical documentation. And now, if ever I'm sick with a migraine, I call out, and they can't treat it as an occasion. They can't ding me on the attendance policy because I'm out for a covered reason. That same employee can come to paid leave authority and say, hey, I'm going to be out. I know I have migraines. I don't know when they're going to hit, but I know they're coming. Here's my med cert showing that I have migraines. When it happens, I'm not going to get paid at work. I'm going to call or upload or go to the portal and say, hey, I had a migraine yesterday. I couldn't work for 4 hours. And you'll get a benefit check payment, not check, debit card or direct deposit from us to cover those 4 hours. The same thing will happen with your caregiver. You're taking care of your mom, and maybe you need time off to take her to the doctor's office or take her to physical therapy, or you are in a family violence situation. So you're a victim of family violence, you need time off to go to court. You know, you're not going to be out for 3 weeks, but you need to be out that day. So it's one leave reason, but several absences. You only apply once, you only provide documentation once, and then you follow up, letting us know and your employer know the specific days that you're, or hours that you're out. Does that make sense?
Yeah, that's what I wanted to hear. So it's basically the same process of filing for a claim, but there's a section in there that you put down intermittent requirements, and the doctor has to approve that, right?
The doctor, or, you
Yeah.
know, again, if it's the court, you know, for family violence. And then, if it is a medical situation, the doctor's going to say, all right, Erin's had migraines since she was 12. We don't know exactly when she's going to have them, but on average, she has about 4 migraines a month. And each time she's out, the flare-ups last 4 to 8 hours. And so there's sort of an expectation of like how much time we could expect the person will be out. And then when it happens, you just report in. And we're asking, because we pay you on a weekly basis, we want to know that you're out. So we ask you to report in within 2 days of being out. Say, okay, all right, I had a flare up on Wednesday. I'm finally, you know, able to look at light again. I'm going to just call into Aflac and be like, hey, it's out Wednesday and Thursday for this migraine. And then you'll get paid next week for that.
Yeah, I have one member that is doing that, and they're saying that you're pretty good about paying right away.
Yeah, that's the
That's
goal.
working out. I just didn't realize it was the same application process. All right,
Same, just that extra step of letting us know when you're actually out.
so I'm gonna let anybody else that wants to ask questions. I know I got people here to ask questions, Janet. But oh yeah, here it comes.
Hi, I'm John Adamson. I'm from the Boilermaker Union. We're just talking about the intermittent leave. Now, so it appears like it was like the old family leave. The doctor fills out the paperwork like we talked about, which says, you know, he could have flare-ups or episodes, you know, so many
Right.
times. What happens, because it's always written as an estimate. What happens within the state, let's say, if the doctor's saying he could miss up to 2 days a month and the person has more flare-ups, it's 3 or 4 days a month. Does he
Yeah.
need to put in more paperwork to back up that it's out of the parameters itself?
So what happens here is that you'll probably need to go get an updated medical certification that has the increase in the frequency, and then submit that. You'll have to usually submit it to your employer because you're taking the family medical leave from your employer. Then we'll take the same med cert. You don't have to get a different one. We'll take the same med cert for your paid leave benefit, and then you still have to call in and sort of follow the same process. 'Cause, I mean, it happens. You have the migraines, and sometimes if you are a caregiver for young, and I say this from my own experience, right? For young kids that have asthma, because my son was asthmatic when he was little, and you know the attacks would just come when they come, and they would increase under certain circumstances. And I would just go back and get a new medical certification. Since it's seasonal, he's going to be out. You know, I need to be out a different amount of time, and then we would do that. So that's how you would manage that. Where people usually run into difficulty is when they don't get the new medical certification and they have an absence pattern that's different from their medical certification. And then that causes employers to say, okay, wait a minute, what's going on here? And that's why it's really better to kind of get ahead of that. And when you see the pattern changing, to go back and get that medical certification.
That leads me to another question. Let's say in the past with the unpaid leave, you know, the company handled it in a way when somebody was going out of parameters, of course, would ask for like an update if the conditions have changed. Let's just say a person is missing 3 days a month. His paperwork says 2 days a month. The doctor feels the 2 days is sufficient. Before the company would try to close the claim if an update is not put in. I mean, would that happen, or would the person just be approved for the 2 days a month continuing on, not the extra day, let's say, if it was happening and the doctor didn't update.
Right. So
So,
I would say that the person, from our perspective, we would continue to pay based on the medical certification. So
Okay.
if they don't come back with a new one, then we're only going to pay them for what's been approved by the doctor. And that's why we really do encourage people to go back and get the other one. And then if they don't get it and then their leave is exhausted and they only have the 2 days or they feel that they need more, there isn't really much that we can do without appropriate documentation.
okay, totally understand that. Also, too, just out of curiosity, so if a person's doing intermittent time and stuff like that, how would you calculate that benefit? Would you calculate on a 7-day work week, a 5-day work week? Because it'd make a difference in the amount the person would receive for the day.
That's right. You said Erin loves this. So I'm going to let her take this.
All right.
That's exactly why we ask about your schedule, because we'll base it on the individual's actual schedule. Because, if you're out for a week, you're out for a week. It doesn't matter if you work 30 hours or 52, but if you normally work 52 hours and you can't work overtime because you're a caregiver or you have an intermittent situation, we're going to base your week on that schedule that gets reported to us. And so it's going to be 1 hour out of 52, as opposed to 1 hour out of 40. So it actually benefits the employee to get those, get that work week accurate. And that's why we ask for that information. Candidly, it's more work for us, but we felt that doing it any other way would actually harm the employees, because they're not going to get, particularly employees who work overtime, they're not going to get the benefit that they're entitled to if we don't account for that overtime. So that's why it's every work week is individualized to the employee.
The one trouble I see with that is, like with us, overtime isn't like a mandatory sort of thing and stuff like that. So you see some people do work overtime, others don't. You could have a month where the individual does work some overtime, but then months that he doesn't. How would that work? You probably answered that already and I missed it.
No, I don't think we got into the details of it. We ask for a 12-week average.
Okay.
So, because employee has to only, for us, an employee could walk into a brand new job and still be eligible for us, but they're not going to get eligible for FMLA and state FMLA until they've been on the job for 3 months. So we want to say, okay, let's go with 12 weeks. That's a fair average. It helps account for some of that sort of smoothing out of those variations. And so when we get the work week, we determine it based on what you've actually worked.
Okay.
When an employer wants to say, oh, a person didn't work overtime, therefore I'm going to count that time against their FMLA, they can only do that if it is mandatory overtime. They can't say, oh, well, you used to work overtime, but we never forced you to, and now you're not, we're going to deduct you. That's not allowed. But if there's mandated overtime that you can't work, they could take that time off the entitlement. So we kind of follow those same rules, but with the recognition that we're just relying on the employee to tell us what hours they were scheduled to work that they didn't work. And if that includes scheduled overtime and they couldn't work it, we'll pay you for it.
All right. Well, that's interesting there. Also, too, when it comes to relationships that aren't blood, but can be considered so, best somebody raising like a child, this and that, I know with the law before you had that Latin word, I guess it was, for a parent.
In
sort of
loco
thing.
parentis.
Yeah, thank you very much.
You're welcome.
I don't say it. But how would an individual prove that, to the state if they're in that situation?
Yeah, the way that that's done is it's actually the purview of the Department of Labor, and they have created a form, and I'd be hard pressed to tell you exactly where you can find it now, but it is on their website and you would be able to get to that form. It's more like an attestation that says this person has this type of relationship to me. It allows you to put in a short narrative about that relationship, and then you would hand that in with everything else. Some states have varying standards. Some of them require affidavits and notarization, but to your colleague's point earlier, it's a very heavy burden for people to carry to try to do all of that. So the Department of Labor has decided that this attestation, upon the penalty of having to pay everything back, if we find out that they're really not that type of relation to you, that's been deemed sufficient from their perspective to be able to turn that in and be able to care for people. And we've actually had people already use it. It's really, we're finding a lot of long-term cohabitating unmarried couples are really using it for
Okay.
that purpose.
All right.
We have a form on our website. DOL has one, but we also have one. We'll accept either.
Yeah.
Okay. All right.
Right. I
great.
forgot about ours. That's right.
All right,
Yeah.
cool.
I'll
Two
put
different
this into
places.
an email to Rich so that you have a list of all the links for these forms. So I'll follow up with him on this.
All right, excellent. Thank you very
Yes,
much.
thanks, Jacqueline.
And then, got to give me a minute to think. Oh,
Take your time.
the other question I have is, the company in the past basically was doing like a rolling year sort of thing. And of course, the state law before on the unpaid, you had to be here a year and so many hours. I know the hours are gone. Now
Hours are
it's
gone.
just going back 3 months. But for example, if I had somebody that, what the employer would do in the old days is that if I put in a claim today or call up to use a day, they'd go back a year, or under the state 2 years. And if I'd already used my allotment, my 640 hours, they deny that day. Has the clock been totally restarted again and stuff like that in the situation now that, starting January 1st, you only have to be employed for, those months and there's no hour requirement? Or can the company still go back, somebody that's had family leave for a while, still go back today and say you've already used your allotment of time? Do you
Yeah.
get what I'm
So
getting?
yeah, I will. Did you say your name was John?
John, yes.
Yeah, John, you got a lot going on there. So we'll try
Yeah.
to parse some of it out for you. Okay. So because it's very common to kind of push together or mush together the paid leave benefit and the family and medical leave benefit.
Yep.
So for the purposes of paid family and medical leave, we use the rolling back period. So employers can still, that is for the purposes of determining whether or not you have the requisite number of weeks available to have a paid leave benefit. Now, employers still have the 4 types of counting periods that they can use, but it's impossible for us to apply those 4 types of counting periods for every single employer. So we decided we were using the rolling back. An employer can still use whatever they have. And if the person has used their allotment, then the employer can deduct those weeks that have been used and then have the person have access to whatever is remaining. The challenge is that sometimes they may not be the same for the paid leave and for the FMLA, which is what I think Erin wants to kind of jump in on. So I'll let her explain that part.
All right, great.
Yeah,
Thank
I mean,
you.
because we're brand new, even though we're rolling, there's nothing to look back at. So everybody got 12 weeks on January 1st from our perspective. But for the employers, if they were already subject to Connecticut FMLA, DOL said, okay, that whole transition from the 16 weeks in a 2-year period to now 12 weeks in a 12-month period, the way they handle that is to say, you can do a look back of 1 year. So if you use Connecticut FMLA, I've got to think about time now, in the beginning of 2020, they can't hold that against you. But if
Okay.
you used it in 2021, they could say, okay, we're going to deduct those 3 weeks you took in August of 2021. So now you only have 12 weeks left until August again in that rolling scenario. So that is something employers are allowed to do, but they can only look back 12 months. The thing that gets a little bit tricky is employees may not have any entitlement under Connecticut FMLA, but they might still have entitlements under federal FMLA or vice versa,
Yep.
particularly for like electric boat, because you're subject to both. Or they may not have any Connecticut or state FMLA, but they could be eligible for income from us. So it's a question of, well, do they have any rights under like the ADA, the Americans with Disabilities Act, for like a leave as a job accommodation? So there's some other laws out there that you should know about that could provide your members with job protection in addition to FMLA. But even if they have no job protection at all, they're eligible for us, at least they're going to be able to get the income replacement from us, even though their job's not held. So
Yeah.
it means that you have to track 3 different calendars.
No.
But again, it kind of ends up generally benefiting the employees.
All right, no, thank you, because to us, of course, too, very important, the job protection aspect of it, so. All right, thank you. That's all I've got right now. Maybe hopefully somebody else has some questions, but thank you.
You're welcome.
While people are maybe coming up to the front, I did want to let you guys know, our statute says that doctors cannot charge employees to fill out the med cert for the Connecticut paid leave program. So I just want you to be aware of that. I can throw the stat in the chat. If that's an issue you're experiencing, have your employees ask for med certs pursuant to our program, and then copy that med cert and give to your employer. Because FMLA doesn't have that provision, but doctors shouldn't be charging. So I just wanted you to be aware of that in case it's an issue for your folks.
Anybody else want to come up and have their moment? All right. There you go.
Hi, good morning. My name is Janet Orr, Machinists Union.
Morning.
So my question today is, because prior to the beginning of this year, intermittent leave was not covered at all with dollars. So I wasn't able to let people know on intermittent leave that they could apply for this.
Mhm.
I've had people that have missed 10 days already since January.
Mm.
How far with the proper accreditation from their doctor can I go back?
Let me just find it, right? Trying to remember.
We said that people should apply no later than 45 days after an absence, unless there's a really good reason for the delay. So if they didn't, so if someone was out sort of the beginning of January, we're probably, we're at past 45 days. But if there was sort of good cause for the delay, we can take that up on a case-by-case basis. And there's, the thing is, we can't kind of have everyone go back. If they come to us in July and say, oh, I want 6 months worth of benefits, we can't manage that. But right now they could apply and give us an explanation.
Okay, on what form would the explanation be?
I think there's a space in the application itself, but if you're having a specific issue with the worker that you're representing, then have them email us directly. If they haven't applied already, then we can help walk them through that.
Okay, so
Okay.
they have not applied already,
Okay,
and we're, February is a short month, so we're like 62 days or so into the
Yeah.
program.
right.
So it would be more than the 45, but with a just reason, should they apply immediately, they would be covered, and then they would just list the days that they were not here.
Yeah.
So,
The quicker they can send this to us, the better. And it's good to send it directly to Jacqueline. And then we have an internal benefits team that can help that person.
thank you very much. You have a
You're
nice
welcome.
morning.
Anyone else? Speak now or forever hold your peace. All right.
I got.
Oh, John's back. All right. No, we want to make sure everybody has full clarification before we end. the
Yeah.
meeting.
Mr. Whatever, because I know when it comes to employer responsibilities, John Adamson again from the
Hi,
board.
John.
Hi. It talks about the verify the absence and other sources of dollar signs as needed. That's the employer's responsibility.
Right.
If a person, and does that, let's say I'm using intermittent. So of course I let the company know, because I should, that I'm going to miss a day. I let the state know. Does the company then have that obligation to automatically send in the verification the person actually missed the day? How would
No.
we do that?
No. So it depends. Sorry, Aaron, did you want to? Okay, it really depends on the type of leave that you're taking. If they're taking in the continuously, I think you're really referring to sort of the intermittent leave.
Yes.
Right,
more
all
so,
right.
yes.
So no, we ask employers to track the intermittent leave independent of what we track. We may ask for that information to verify what we may have, and we may do that on an audit or case by case basis, especially if we see that there's a significant difference in what the person is experiencing with respect to absence as opposed to what's on their medical certification. We'll ask under those circumstances. But when a person is out, it's really up to the employee. It's their responsibility to report it to us, and they also should be reporting it to their employer. We say this over and over and over again. It's so important to keep your employer in the loop because you want to make sure that you're exercising that job protection. You want to make sure that if you're absent, that they're not attributing it to anything other than family and medical leave that you have job protection for, because you really don't want that to end up being a discipline issue, or having to file a grievance because you've been disciplined because you were absent when actually it should have been covered under FMLA. And we also want employers to keep track, because what we don't want to have happen with workers is that they end up exceeding that 12-week window because the employer wasn't keeping track. Now they're in week 13 and they're out again because they didn't know that they've run out of their leave, and now they're outside of that job protection window. Now they've got an issue. That's why it's important to do all of that. And we also really strongly encourage employees to keep track of their own time too. A lot of them use Chronos and Paychecks and all these things. Just go to HR and get your printout and keep track of it yourself so that you too can be empowered when you have to either defend or in some way show that you've been at work, or your absences are based on your medical leave that's been approved.
Yeah, I think you're quoting from one of our slide decks where we list like employee responsibilities.
Yes.
Part
Yeah.
of that is just to put the employers on notice that it's possible we might come back to them and ask them for some information, right? We've like, look, you definitely need to fill out the employment verification form. You definitely need to let your employees know what your policies are. And oh, by the way, like, we may come to you and say, hey, could you please just verify for us? In the event, that they were doing like a fraud investigation, or we want to make sure that, we've been paying very close attention, as Andrea said, to the whole DOL unemployment insurance. And they experienced a fair amount of situations where people were stealing other people's identities and applying for benefits.
Oh, wow.
And then the real person comes in and they're like, well, you already got all your benefits. We don't want that to happen. And so, one way of making sure that doesn't happen is to just do those sort of spot checks. So that particular slide was really more about putting employers on notice that
And you could
we
reach
might
out
come
to them
calling.
and say, and verify whatever the employee.
Exactly. What we don't want is we don't want employers to become lax because they believe that we're doing all the work with respect to tracking leave. They still own that responsibility. We really wanted to make it clear that it still belongs to them. For the smaller employers, those that had 74 or fewer employees for whom family medical leave is new, we're trying to guide them through their process. But for large established employers who've been administering family medical leave on the state and federal level for a long time, we're saying to them, do not abandon your practices because there's paid leave. You still have those responsibilities.
All right, great. Well, thank you very much.
Welcome.
Going once. Going twice. Sold. All right. Peter, are you closing it? No, all right.
Just say, Tom, thank you, and
All right, so he said, thanks for being in touch. I just wanted to double check with the person recording who they're going to send the recording to.
I have Rich's email address, so I probably will be sending it to him.
Okay, that's perfectly fine.
Yeah.
Thank you.
Okay.
I just want to make
And I
sure
know-
it's going somewhere I could get it.
You can get it. And, I know that Rich had to step away. We're happy to have these meetings as often as you like. We're available. Let us know. If you go back, you think about more stuff, let's schedule another time together. We want to be helpful.
Okay, thank you so much.
Okay. All right. You're welcome.
All right.
Have a
Thank
great
you.
day.
Okay.
Okay. Bye.
Thank you.
Welcome.
Bye.
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 Bye.